Today, I will explain the basics of trusts. A trust is a system to entrust administration and disposal of property to a trusted person. The origin of the current trust is said to be a use system established in England in the 11th to 13th centuries. The use system at that time was utilized by knights and aristocrats. When they were absent from home to join the Crusades, they let trusted people manage their land for their families. Another example are followers of the St. Franciscan order that also utilized the use system to donate land to the order. In the case of the Crusades, entrusted relatives and friends managed land on behalf of the knights or aristocrats in the field, and provided and generated profits such as rent and harvests with their family members, and then returned the land to the knight or aristocrats when they came back safely. As for donations by followers of the St. Franciscan order, followers could not donate land to orders directly because orders and monks were prohibited to own land. So, followers transferred their land to local villages or towns and donated profits generated from the land to orders. As mentioned just now, under the use system, land was donated to orders or churches. As a result, monarchs lost control or authority to impose tasks on those lands, since orders and churches were not under the control of monarchs. Therefore, monarchs prohibited the use system. Nonetheless, there was great need for the use system. At one point, courts recognized the use system as a legitimate system. Then, in addition to land, money and securities were included as target properties of the use system. In England, the use system was developed as a legal system and finally established as a trust system in the 17th century. The United States inherited the trust system, and in the 19th century, corporate organizations entered a field of trusts. The Civil War started in 1861, which promoted infrastructure projects such as railway construction and mine development. Here, to raise a large amount of funds necessary for those infrastructure projects, trust companies underwrote bonds issued by railway companies and mining companies and sold those bonds to people. The characteristics of trusts in the United States are, first, corporate organizations engaged in trusts as business, and second, trusts that are used as finance to raise funds. The trust system was introduced to Japan by the enactment of trust laws from the Taisho era to the Showa era, meaning around the early 20th century. Since Japan did not have a concept of a trust system until its introduction, Japan accepted and introduced the system and concept of trusts from the United Kingdom and the United States as it was. In Japan, the trust system was introduced as business trusts operated by company organizations in the financial sector. Since the launch of the trust system, the development of the system have been promoted by trust companies and trust banks. Here, I'll explain the structure of a trust in basic technical terms in relation to a trust. As mentioned earlier, a trust is a mechanism under which someone entrusts administration and disposal of his or her property to an entrusted specific person in order to give profits generated from the property to other people such as family members. In Japan, the mechanism is stipulated by relevant laws. So it can be said that a trust is a property management system which enables a person who owns property make a specific person administer and dispose the property in accordance with a certain purpose. In other words, a trust is a legal system that an owner of a property can use when the owner intends to give the property or profits generated from the property to other people, such as family members. But for some reason, the owner cannot administer or dispose the property or wants to entrust administration and disposal of the property to someone with specialized knowledge and qualifications. Please look at the slide. I will explain further with this picture. First, there is a person who owns property and intends to give profits generated from the property to others and entrust the property to a specific person. This person is a settlor. A settlor entrusts his or her property to a specific person to achieve a certain purpose. The specific person who has entrusted property from the settlor is a trustee. Either an individual or a corporation can be assigned as a trustee. However, since a trustee performs judicial acts such as administration and disposal of property, people in certain categories, for example, minors and adult wards, cannot be appointed as a trustee. Commonly used trusts are created by an agreement or a contract between a settlor and a trustee. An agreement to establish trust is called a trust agreement. When a trust agreement is concluded, a settlor transfers property to a trustee in accordance with the agreement, and the trustee undertakes the property. Once transferred, ownership of the property, including the name of the property and authority to manage and dispose of the property, are transferred from a settlor to a trustee. This is called the creation of trusts. Property transferred from settlor to a trustee is called trust property, managed separately from the trustee's own property. In further detail, trust property means that the entire property that a trustee is responsible to administer and dispose. Each respective property belonging to trust property is called property that comes under trust property. After creation of a trustee exclusively administers and disposes trust properties on behalf of a settlor. Unlike an agent, the trustee conducts transactions under his or her own name, and these transactions have effects on the trust property. Here, administration and disposal of property by the trustee is carried out within the scope of a certain purpose indicated by a settlor at the time of the creation of a trust. The certain purpose the settlor intends to achieve is a purpose of the trust. The trustee must carry out administration, disposal, and other actions for the trust property in accordance with the purpose. Therefore, a purpose of a trust is also standard for a trustee to determine what kind of administration and disposal a trustee should carry out. A trust is to be terminated when a purpose of a trust is achieved or can no longer be achieved. Next, a person who will have benefits from a trust is a beneficiary. Once a trust is created, a beneficiary acquires rights to receive benefits of the trust without any special procedure. This right is called beneficial interests. As explained, a trust is a property management system, which is a legal relationship among three parties: a settlor, trustee, and beneficiary in relation to trust property. However, under the current trust system, the relationship among these three parties is not fixed. A person in one position can take another position. For example, a settlor can be a beneficiary at the same time. This type is called a self-interest trust, since a trust is set up by a settlor for his or her own benefit. A trust whose beneficiary is someone other than a settlor is called a trust for interest of others. Under the Trust Act, a trust can be created by making a will or trust declaration in addition to concluding a trust agreement. However, concluding a trust agreement is the most popular way. So, first of all, I'll explain how to create a trust by agreement. In a trust agreement, a settlor who will utilize a trust and a trustee who will undertake the trust agree that the settlor transfers property to the trustee, and the trustee administers and disposes the property for the settlor in accordance with a certain purpose. It is called a trust agreement since a settlor and a trustee agree to create a trust. In other words, in principle, a trust is created by concluding a trust agreement. Transfer of property is completed by assignment of property from a settlor to a trustee. In the case of creation of a trust by agreement, the trust is effectively created when concluding the agreement, even though the property is not actually transferred from the settlor to the trustee. If a trust agreement is concluded, a settlor shall transfer property to a trustee. In most trusts today, trustees are trust banks that engage in trusts as business. In this case, a trust bank and a settlor conclude a trust agreement by writing, or a trust bank delivers trust clauses prepared in advance to a settlor. These written trust agreements, or trust clauses, describe matters necessary to clarify contents of a trust agreement. For example, date of agreement, name of a settlor, trade name of a trustee trust bank, a purpose of a trust, property to be transferred to a trust bank, duration of a trust, means of administration, and disposal of trust property. Furthermore, in order to create a trust, it is necessary to decide and prepare to trust property. This can be done not only by transferring property from a settlor to a trustee, but also by creating rights for a trustee. For example, a settlor can make trust property by creating security rights such as mortgages or lease on lands for a trustee. Second, a will. A trust can be created by making a will. A will is sometimes called a testament or last words. Here, a testator makes a will that designates a specific person as a trustee and lets the person administer and dispose of the testator's property. For example, transfer, creating security rights, in accordance with a certain purpose after the testator's death. Here, a trust is created when a will takes effect, that is, in Japan, when a testator dies. However, if a person designated as a trustee declines to undertake a trust, the trust is not created. In this case, if an interested person files a petition, a court can appoint a trustee. Third, trust declarations. When creating a trust by trust declaration, a settlor declares that the settlor assigns himself or herself as a trustee and administers and deposes portions of his or her property as trust property separated from other portions. This is called a self-trust because a settlor is also a trustee. It was established and widespread as one of the methods to create a trust in the United Kingdom and the United States, but not admitted in Japan. However, it was admitted when the Trust Act was amended in 2007 in order to, among other reasons, to promote asset liquidation. Regarding trust declarations, there are no visible changes for others to recognize transfer of properties from a settlor to a trustee. Therefore, it is required to make declarations by a notarial deed or other documents or electronic or magnetic record in order to officially specify the date of declaration, so that third parties can know when the portion of property is separated from other portions as trust property. We cannot say that a self-trust is fully utilized in Japan today. However, it has been considered how to utilize it in various fields. First, a trustee's duties. Since a trust is a system that a trustee manages and disposes property entrusted from a settlor in accordance with the purpose of a trust, the role of the trustee is important. The trustee is granted exclusive administration and disposal authority, and, on the other hand, is imposed strict responsibilities and obligations in his or her acts. Main duties of a trustee are duty to carry out processes connected with a trust, duty of care of a good manager, duty to work faithfully, and duty of separate administration. A trustee must carry out processes connected with a trust, including administration and disposal in accordance with the main purpose of the trust. The main purpose of the trust is an intention of a settlor to create the trust. Thus, in other words, it can be said that a trustee has a duty to carry out processes connected with a trust to achieve a purpose for which the trust is created. This duty is duty to carry out processes connected with a trust. Furthermore, when a trustee carrying out processes connected with a trust, the trustee must carry it out with care of a good manager. This duty is called duty of care of a good manager. The level of this duty is decided based on the objective level of care which is ordinarily required for a person in that profession or position, not decided based on the actual competency of a trustee. That means if a trustee is an expert, such as a trust bank, the trustee must carry out processes connected with a trust with ordinarily required level of care of experts, not the level of a non-expert individual. If a trustee causes damage to trust property due to the violation of a duty of a care of a good manager in the course of carrying out processes connected with a trust, the trustee is liable to compensate for damages. A duty to work faithfully is the base of a trust that obliges a trustee to carry out processes connected to a trust faithfully for a beneficiary's interests, not for the interests of the trustee. It is also said that a trustee shall not be in a position that creates a conflict of interest between the trust property and the trustee. For example, the following acts are prohibited. Number 1. Transaction between a trustee and trust property, or so-called self-transaction. That is, to include property that comes under trust property in the trustee's own property, or to include the trustee's own property in the trust property. Number 2. To include property that comes under trust property in trust property of another trust. If a trustee conducts these acts in violation of a duty to work faithfully, such acts are null and void. However, a reason to prohibit acts that create conflicts of interest by a trustee is to prevent harm on a beneficiary's interests, and so it is not necessary to prohibit these acts if the beneficiary's interests will not be harmed. Therefore, when a trust agreement has provisions to allow, or when a trustee discloses important facts and obtains approval from a beneficiary, the trustee can carry out acts mentioned above. In practice, for example, when a trust bank is a trustee, acts that create a conflict, such as foreign exchange transactions at market rates or providing loans at market interest rates for trust property, are carried out. Duty of separate administration is a duty of a trustee to separate property that comes under trust property from the trustee's own property and property that comes under trust property of other trusts. This duty is necessary, for example, for the following reasons. If trust property and a trustee's own property are not distinguished, the trustee cannot properly carry out processes connected with the trust. Or, in the case of compulsory execution against trust property, is carried on request of a creditor of a trustee, a settlor cannot file an objection because the settlor cannot prove the property in question belongs to trust property, not to the trustee's own property. In addition to these duties, a trustee has a duty to prepare books and make reports for a settlor and beneficiary regarding status of the administration of trust affairs. Furthermore, if any loss or change occurs to trust property due to a trustee's breach of duties, the trustee is liable to compensate the loss or restore the trust property. This is a duty of compensation or restoration of trust property to a trustee. Since the trustee manages and disposes trust property on request of a settlor, the trustee may receive reimbursement for expenses necessary to carry out trust affairs. Furthermore, a trustee can receive trust fees or remuneration when the trustee undertakes trust affairs as business, or the trustee and a settlor agree. Next, beneficial interest. A person designated as the one who is to be a beneficiary by a creation of a trust acquires rights as a beneficiary without any other procedures. This right is beneficial interest. Beneficial interest includes two rights. First, a right to demand delivery of property that comes under trust property or distribution of profits derived from trust property to a beneficiary. Second, a right to supervise a trustee. The first one, the right to obtain profits from trust property, is the distribution claim as a beneficiary. For example, if a trust holds real estate as trust property, a beneficiary has a right to receive profits derived from the real estate, such as sales price or rent. That means a beneficiary can receive the same benefits as he or she owns the real estate directly through a beneficiary interest. Since the legal nature of a beneficiary interest is a claim under private law, it is in principle assignable. That is, a beneficiary interest may be assigned to a third party easily pursuant to rules of assignment of a claim under private laws. For example, if a beneficial interest is divided into two or more by a trust agreement, it is possible to assign part of them. Thus, if a trust holds a piece of real estate as a trust property, it is possible to divide rights to obtain principal and interest from the real estate into multiple small lots by dividing a beneficial interest. In addition, to assign or transfer a real estate usually takes much time and cost. However, to convert real estate to beneficial interests makes transfers easy. This function is called the conversion function of a trust. Furthermore, various arrangements are possible. One example is a beneficial interest with priority subordinated structures, which is to distribute preferentially principal and profits to certain beneficiaries and distribute remaining principal and profits to other subordinated beneficiaries. Another example is to divide a beneficial interest into one to receive principal and the other one to receive profits. Since various types of beneficiary interests can be created, various types of financial instruments are offered by combining those beneficiary interests and offered as money trusts. In addition, trusts with certificates of beneficial interests, that is to issue certificate of beneficial interests, one of the securities, was approved by amendment of Trust Act in 2007. Besides a trust, there are other property management systems such as agency by mandate or bailment. Agency by mandate is a system to let another person represent a principal, manage and dispose property based on delegation of authority from the principal. One of the big differences between a trust and an agency is, in the case of agency, unlike a trust, ownership of property is kept by a principal and not transferred to an agent, and thus the principal can also manage and dispose the property. As for bailment, although a bailee receives property from a bailor, ownership of the property is not transferred to the bailee. The bailee has obligations to keep the property safely and return, but does not have authority to dispose the property. Deposits is legally categorized as a deposit of fungibles, one of the bailments. Once a depositor makes deposits, the money belongs to a financial institution, and the financial institution returns the same amount of money to the depositor at maturity with interest agreed in advance. Unlike a trust, investment profits generated from management and disposal of the deposit money is taken by the financial institution. In summary, characteristics of trusts as property management systems are as follows. Number 1, a trustee has ownership of property and has exclusive authority to manage and dispose property. Number 2, a trustee must exercise his or her administration and disposal authority not for his or her own benefit, but for benefit of a beneficiary within a scope of certain purposes a settlor intends to achieve. Number 3, a trust can be created not only by agreement, but also by a will or trust declaration. Number 4, in principle, a trust continues to exist even if the relevant parties of the trust, meaning a trustee, a settlor, and beneficiaries, die. When a settlor is a corporation, trust continues to exist even though the corporation is dissolved. And number 5, trust property is not involved in bankruptcy proceedings in case a trustee, a settlor, or beneficiaries go bankrupt. This is called the bankruptcy remoteness function of a trust. As a property management system, a trust has three main functions: the property management function, the conversion function, and the bankruptcy remoteness function. Under the property management function, administration and disposal of property can be entrusted to a trustee with expertise, experience, and know-how for the benefit of a settlor or a beneficiary. With this function, funds placed in a trust by many people can be efficiently managed in one bundle. For example, financial instruments such as money trusts and pension trusts rely on trust banks, experts of asset investment and management. As for trusts created to liquidate real estate or monetary claims, knowledge and know-how regarding real estate and monetary claims are utilized. Next, the conversion function is a function to convert trust property into a beneficiary interest, a right under private law, which makes transfer or sales of the property easier and reduce necessary costs for relevant procedures. Furthermore, various financial instruments are offered in response to complicated and sophisticated demands by creating a wide range of beneficiary interests. Finally, under the bankruptcy remoteness function, trust property is transferred to a trustee and separated from a settlor, and thus the trust property is not affected by bankruptcy of the settlor. Furthermore, the trust property is not affected by bankruptcy of the trustee either, since the trust property is separately managed from the trustee's own property. This function makes it possible to utilize a trust as a means of asset liquidation.